So as I say, we introduced these taster sessions for some of our courses, just to give a feel of, people who may not have been sure, do they want to come along to a one-day course or a particular course? And we thought it was worthwhile putting on a 1 hour taster session just to make sure that the course is right for you. So I hope you find it useful. I'll just do a quick introduction of Ian Quayle of IQ Legal Training Limited. Ian is a qualified solicitor, and he's been training in land and property law for over 20 years, and he's been doing some sessions with IHE for the last approximately 3 years. Yeah, lots of experience as a solicitor in various development issues, boundary issues, conveyancing, and he does a lot of conveyancing training for people like Land Registry, Institute of Licensed Conveyancers, etc. So, Ian, I'll let you kick on, and thank you very much. And as I say, everyone, please put questions in the chat as we go along. Over to you.
Thank you, Lyle, and good afternoon, everyone. Thank you for joining us. Yes, my name is Ian Quayle from IQ Legal Training. I live in the northeast of England, but spend my life travelling up and down the countryside, boring people to death, talking about all manner of different matters, mainly legal-related issues, mainly land law-related issues. And I've been delighted to work with the IHE in connection with highway law, looking at a variety of different topics. And I was talking to Lyle a little earlier about this. One thing that I find really fascinating about presenting work for the IHE is the variety of attendees. So we could have on one occasion people who are specialising in arborology and looking at tree issues with regard to the highway. We can look at sort of health and safety issues, inspectors, and even the sort of rank and file actually dealing with potholes. So when I'm attending face-to-face events, that we get a whole spectrum of highway authority, county council and council employees coming at highway issues from a variety of different angles. And to be honest, I love it. Normally, the training I do is with solicitors and barristers, and between us, and I don't want to tell anyone, dead boring, because I get asked the same questions about the same old things, which are horrendous. From the perspective of what we're talking about today, the thing I love is the variety. So we can be asked loads of questions about things like adverse possession, land registration and boundaries, drop curbs, accidents involving children playing on bollards, you name it. So the width of different things and different topics that I examine during the presentations that I do are huge. The way I operate is the face-to-face course lasts for a day. And I start off looking at some basic principles. And what I'm going to do today is sort of basically give you a snapshot as to how the day evolves. But I was just saying to Lyle, one of the things I really like doing is during the day having a Q&A session in the morning and in the afternoon. And that can last up to an hour, where delegates just fire away questions. And it's not me necessarily providing a response, it's the group collectively coming up with ideas, etc., and me simply sort of highlighting issues. And every now and again, I'll be asked a question and I know the answer to it, or commonly I'll go scurrying off after the event to try and find out an answer. And again, I really like the fact that I'm asked questions, because if I don't know the answer, I can go scurrying off and find it and then use it in connection with future presentations. So first things first, as far as I'm concerned, I am a lawyer. I am a specialist sort of land lawyer. I have developed an expertise to an extent in connection with highway matters, and I spend lots of time looking at questions from solicitors and barristers concerning highway law, issues from developers, and consultancy work on behalf of highway authorities, local authorities and county councils about highway related matters. So if you'll bear with me, what I'd like to do is take you through some slides, which gives you a flavour of the sorts of things we'd encounter with regard to a day-to-day face training. I was talking to Lyle and Cheryl just earlier about it. What I'm really interested in doing, as well as that, and in combination to what we're talking about today, is doing sort of modules by way of virtual training of, say, an hour session on particular topics. But that's something that Cheryl and I will talk about. But that might be something that could be of interest. I'd be very interested to know in the chat whether people would like that. So perhaps we could do a webinar or something of that nature on, say, dropped curbs or electric vehicle charging points, in addition to the day-to-day training, which is really what I'm talking about this afternoon. So who am I? There you go. Very boring, specialist property lawyer. Very unfortunate, really. But apart from being a lawyer, I'm also really interested in developing issues, and highways are ancillary to that. So the course structure, let's assume that you're looking at a day's IHE training on highway law. What would it look like? Well, I start off by talking about relevant land law, because I think it's important that if you're working on highways, you need to know some of the important principles associated with land law: freehold and leasehold ownership, easements, rights of way, etc. The role of the land registry, because one of the things I'm commonly asked about is, we're a highway authority, we have a problem with an adjoining landowner. He's got heavy vehicles that are crossing onto the highway, spreading mud, creating a mess, etc. What can we do to stop him? Or we've got a farmer whose fields are flooding, they're coming onto the highway. Can we clean his drains out? Can we install new drains, etc., etc.? So I think it's important that we look at some land law principles that can help you as a highway authority. So, if you know about leasehold and freehold ownership, and the farmer says, well, actually, I own the freeholds to the farm, but I've let it to a contractor to grow crops, etc. Important to understand the status of the landowner and status of tenant. Important to understand the fact that land registration gives us open access to land ownership. Also important to understand and appreciate that registered land creates a difficulty in that the land registration process does not enable us to identify legal boundaries. The legal boundary between a highway authority public highway and my land, if I'm an adjoining landowner, will be a pencil line that separates our respective ownership. The moment that's converted into a land registry title plan, it becomes a red line on a plan that's 1.5 meters wide, or if it's denoted on an ordnance survey plan, it could be 2 meters wide. And as a lawyer, I'm saying to you that plan is useless, because the legal boundary is a pencil line that separates our respective titles. We might be arguing about maintenance of a tree that's diseased, and who's going to fell it and who's responsible for risk associated with that tree. And if that tree root or the tree trunk is somewhere in the middle of the red line or the black line on an ordnance survey plan, we've got a problem. So that's a really interesting question that relevant land law doesn't necessarily help us to answer, but highlights where the problem is and also indicates what we can do to try and fix legal boundaries or sort out issues of that nature. So that's an area where really I'm delving into land law principles that are suitable for highway authorities, employees in various guises. And then I start talking about highways themselves. What is a highway? How we distinguish the highway. And the peculiar thing about highways is that when you acquire, as a highway authority, the highway, you own the surface of the highway, you acquire ownership courtesy of your status as a highway authority, but there isn't a transfer. If I'm a private landowner or a developer, there isn't a formal transfer document that transfers title or ownership to you. So normally in a standard conveyancing transaction, if I'm selling you a bit of my garden, we will have to lodge documents at the land registry to prove that I own what I'm selling you, and to prove what I'm selling to you, and the land registry will record that. Well, unfortunately with highways we don't have that benefit. So we talk about highways, and I'll show you some slides related to that in a second or two. We talk about private roads and the rights and extent of the highway and features of the highway. Again, really interesting stuff, combining some of the things I've mentioned to you in connection with land law principles. Then we talk about highway management, liability and control, grass cutting, dealing with mud on the road, dealing with flooding, dealing with incidents with regard to road closures, temporary road closures because of accidents or whatever. Then sometimes, depending on attendees, we'll talk about development management, so Section 38, road agreements, etc. And we'll talk about how to deal with developers, what a Section 38 agreement should contain, what a developer might be looking for, why you as a highway authority might be unwilling to adopt roads and footpaths on a new development, why a developer might not want you to adopt, or where they might want you to adopt, this sort of thing. So that can be really interesting. Sometimes the audience won't be involved in development and therefore not necessary. Then we'll talk about traffic management, car parking, etc., which is interesting. And we'll have a look at issues associated with signage and all that goes with it. So what I want to do now, they're the main topics that we explore. Oh, I forgot to mention, we also look at dealing with members of the public. So meeting Mr. Smith at the roadside to discuss a pothole, talking to Miss Brown about a drop curb, talking about a potential dispute concerning trees. So how to deal with members of the public from a lawyer's perspective, negotiation, subject to contract meetings, without prejudice meetings, etc. And we also talk in the course about giving evidence at court. So are you giving evidence of fact? Are you an expert giving evidence before the court? That sort of thing. I'll show you some slides relating to that in a minute or two. So land law relating to highways, just a snapshot. We talk about relevant law, decisions from judges, delegated legislation, Act of Parliament, the Highways Act, of course. That's all standard. But we also talk about custom and practice, manorial rights, legal presumptions, the sort of hedge and ditch rule for boundaries, hedge to hedge rule with regard to highways, etc. And we talk about something called proprietary estoppel. Generally speaking, for contracts for the sale or purchase of land, there has to be an agreement in writing. But in certain circumstances, if you promise something to an adjoining landowner and they act to their detriment on the strength of that promise, in law, that promise has to be honoured. So if you're a highway authority and I'm a landowner and you say to me, Ian, look, we've got a problem with regard to your ditches. If you start cleaning out your ditches and you install a new ditch on your land to stop flooding onto the highway, that bit of land there that we own that isn't highway will give to you. If there isn't an agreement in writing, but I do what you've asked me to do, then theoretically that land then belongs to me due to a principle called proprietary estoppel. And the other thing about equity that's quite interesting is obtaining an injunction. So I was talking to someone just on Friday about this issue. They had a situation where a restaurant was putting tables and chairs on the pavement part of the highway. And the highway authority was aware of what they were doing and hadn't done anything to challenge them, and was now concerned because I think someone had tripped on a chair and they'd had complaints from the public about the fact they're having to go on the road to navigate the pavement because of the chairs and tables, etc. And therefore they were asking me, well, what steps can we take now to stop the restaurant doing what they're doing? And what I said was, well, if you're aware of an obstruction of the highway and you fail to react to it, you're not necessarily going to be able to go to court and get an injunction to stop them. There are things that you can do to enable someone to continue doing what they're doing whilst reserving your legal position so that you could bring proceedings if you wanted to at some point in the future. So we discuss all of these sorts of things and put it in the context of the work that you do. I think someone's got their microphone on. I'm getting a bit of feedback, but hopefully you're not. So again, just a deep dive. We talk about registered land and the fact that if land is registered and I'm an adjoining landowner, you don't need my permission to actually see my title to the land that I own. So you can look at the property register, proprietorship register, charges register, and title plan at the click of a button. So Lyle's in dispute with me in connection with highway authority and adjoining landowner. I'm saying to Lyle, I'm not going to tell you about what I own and what I don't own. Get lost. If the land is registered, Lyle can simply go on the land registry website, put in a postcode, put in an address, and immediately download my title and see exactly what I own, see perhaps that my property is subject to a mortgage in favour of the Agricultural Mortgage Corporation, and do all sorts of investigative work without my involvement at all. So why do I do this about basic land law principles? Well, for these reasons. Does what we talk about with land law really matter? Well, of course it matters. Who owns that hedge? Is the grass verge part of the highway or isn't it? Who owns the house on the photograph to the right-hand side? Do they have a right of way I've I'm going to unmute myself, hopefully. So hopefully you can see me. So these sorts of issues will be things that you're encountering on a daily basis. In an urban context, if I've got a cellar underneath the highway and I want to build a gymnasium or a 4-car garage to expand the cellar, can I do it? If I want to, if I own both sides of the highway and I want to undertake some form of airspace development, can I do that? These are the sorts of things that can occur, and we need to know about relevant law to enable that to be done. I know, James, we've got a question there. What I'll do is deal with that in a moment or two, if I may, when I come to that topic. So, highways. We're going to look at those sorts of issues. And of course, we're going to talk about the London Borough of Southwark and the Transport for London case, where the Supreme Court gave a modern definition of highway, not just the surface of the road and 2 spits beneath it, but a zone of ordinary use, which means a reasonable depth and a reasonable height to enable you as a highway authority to perform your functions, a right of support, etc., relating to the highway. So we have a deep dive into that. And when we do so, if we look at this case, we've got a zone of ordinary use, a reference to physical elements, that means the highway can include surface, structures, bridges, etc., a right of passage and repassage, which would also include a right to access cul-de-sacs. So we have a long and detailed look at that, including the modern interpretation of what is highway. And at the end of the spectrum, we look at ancient highways and Roman roads, etc., and to what extent such an ancient highway can be maintainable at the public expense. Again, normally involving a bit of a long, hard look at the Highways Act 1980, in this context, Section 36. We then look at the creation of highways and this idea of dedication, and we look at implied and express dedication and the significance of it. Why would I, as a landowner, want to dedicate a private road on my land as highway? Would I be prepared to do so if I knew the potential risks associated with such a dedication? I'm far more likely to be willing to contemplate dedication if you as a highway authority are prepared to adopt, in those circumstances, the risks that I have with regard to access, repair and repair and maintenance are to an extent dissipated. So we talk about the creation of highways and have a deep dive into dedication and indeed adoption, looking at express dedication under Section 38 and deemed dedication under Section 31. The interesting thing about this dedication, deemed dedication, etc., is it pretty much mirrors the law relating to easements and rights of way. So we have a sort of bit of a compare and contrast with regard to private rights of way and dedicated highway and adopted highway, which again is interesting and encompasses lots of different issues. So then we talk about management of the highway, and we look at maintenance of the roads to a safe and passable standard. So what about complaints from members of the public? What about our inspection teams? How regularly do they inspect? What are they inspecting? To understand and appreciate that we're fortunate in that the law and the courts enable us to have a degree of flexibility with regard to management. No obligation on us to ensure that all roads and footpaths are sort of bowling green level surfaces, to make sure that we understand and appreciate that we're entitled to consider our resources, what the highway is used for, where it's situated with regard to our inspection, repair and maintenance strategies and policies. One of the things I'm really interested in, particularly in the current economic climate where budgets are being reduced, are we revisiting our strategy with regard to inspection, repair and maintenance. What is reasonable in all the circumstances? When do we review? How do we review? How do we record reviews? Because all of these things can be interesting and indeed significant when it comes to defending proceedings relating to slips and trips, road traffic accidents, etc., where there's a degree of potential highway authority culpability. So we look at all that again in a lot of detail. This is just one slide from a number of slides in my slide deck that we would look at to deal with it. And we talk about case law again, about what our duty is relating to the highway, keeping it reasonably safe, and looking at how an action for damages relating to breach of statutory duty under the Highways Act would look. Claimant showing the road was in a condition as to be dangerous to traffic, proving the dangerous condition was due to a failure by the highway authority to maintain, which would include a failure to repair, and then consideration of the special defence that's available to highway authorities in certain circumstances. So the ability to prove that the highway authority had taken such care as in all the circumstances was reasonably required would enable a defence to succeed and a claimant to fail in a claim for personal injury. So then we have a look at the famous Section 58 defence, failure to maintain or repair, not applicable where repair has been undertaken negligently. We'll look at the role of contractors that we use with regard to liability in that context. And again, I've just given you a snapshot of the things that we look at. And then we jump ship and look at liability in tort, in other words, negligence. So if I'm bringing a claim against a highway authority, I'm going to look at a breach of the highway authority's duties under the Highways Act. I'm also potentially going to allege negligence in that the highway authority owes my client a duty of care. There's been a breach of that duty and my client has sustained loss as a consequence. So we'll have a look at both claims, which are generally speaking brought in tandem. And then we'll have a look at, and this really is an area, Lyle, that I enjoy, looking at snow, ice, mud on the road, etc., and looking at what the Highways Act says and what we're obliged to do and to what extent our budget is a factor that the court will consider. And that's the good news. As a private individual, my resources in connection with ensuring that visitors to my property are safe are not taken into account, whereas you as a highway authority, your resources, your budget is a factor. So we'll look at snow and ice, mud on the road, flooding, etc., all of these things, and ascertain what you can do to prevent claims, how you can manage claims, and we also have a look at litigation and litigation risk. And one of the things I always say to every highway authority is, look, the vast majority of litigants in court proceedings take an economic view, not a legal view. So we may have a claim that's well worth defending, or we may have a claim that's well worth pursuing, but we've got to look at the economics of those proceedings. If I said to you a simple county court action that ended up with a day's trial could cost you as a highway authority £50,000 to bring proceedings to court, and if I also told you if you lost those proceedings, you'd be liable for the other side's legals, another £50,000, and the claim is worth £10,000, how many people would say to me, Ian, what a great idea, let's go to court? So I'm saying your upside is a £10,000 win, your downside is a £100,000 loss. How many people would say that's a bet I'm prepared to take? If I then built into that equation, I can't guarantee that you'll successfully win or you'll successfully defend the proceedings. How much of an appetite would you have to bring proceedings or defend them? And if I said to you, it might take us 2 years to get to court, is that going to really sort of float your boat and say, yeah, litigation is great? I would always say to someone, you've always got to think about the economics of the proceedings. You've also, to an extent, as a highway authority, need to think about negative publicity relating to it as well. So sometimes, and again, with my lawyer's hat on, I'll say to someone, well, we could bring a claim and seek an injunction or seek damages. But the reality is your vulnerability is potentially £100,000 and I can't guarantee a win. Why not just sort the job out and use some of the £50,000 worth of legals to resolve the problem? Now, just as much as that is an issue for you as an authority, it's also an issue for a potential claimant. However, the problem that we have with regard to slips, trips, road traffic accidents, any form of personal injury these days, is lawyers will work on no win, no fee. So if I'm bringing a claim against a highway authority and my solicitors are working on no win, no fee, if I lose, I don't have a big legal bill. And if I lose, I don't have to pay your legal costs, because if my lawyer is working on no win, no fee, they'll take out an indemnity policy, an insurance policy to cover your legal fees. That means Mr. Claimant or Mrs. Claimant has little or no risk with regard to bringing a claim. And that's a massive problem with slips, trips, road traffic accidents, etc. on the highway where there's a personal injury element. Andrew, I'm going to cover exactly those cases. We'll look at Gilkinson, Barlow and others that cover whether a path is highway maintained at the public expense. So we do cover those cases, yeah. All I'm doing, Andrew, is just giving you, because time doesn't permit, of course, a snapshot of some of the things that we look at, okay? And the other thing, Andrew, is in a Q&A session, we'd talk about accidents concerning paths, cycle paths, etc. as well, depending on who's attending the event. So flooding, again, I'm often asked about this, very interesting point. If I own a hillside and your highway is at the bottom of the hillside, I am under no obligation to prevent rainwater runoff onto the highway. However, if I were to divert a stream, or if I were to create ponds to prevent flooding on my land, and those ponds overtopped or the stream spewed out onto the highway, I could be liable for flooding on the highway. And again, you as a highway authority are under an obligation to keep users of the highway reasonably safe, which would again involve addressing flooding issues on the highway to prevent accidents. So I mentioned a couple of cases here. There are more that we could look at where we have situations where there is flooding on the highway causing aquaplaning and causing road traffic accidents. To what extent is a highway authority either liable or contributory negligent towards such accidents? And Burnside and Emerson, Tarrant and Rowlands are two very similar accidents where highway authority was held to be a third liable for loss or 50% liable for loss, the differential being the sort of highway. In Tarrant, where the highway authority was liable for half the loss that the claimant sustained, the judge said this was a busy road with fast traffic, and therefore the obligation on you and the highway authority to ensure users of the highway were kept safe was greater. You failed in that duty. Yes, the motorist that aquaplaned into another vehicle was responsible for the accident, but, said the judge in that case, you as a highway authority are equally responsible. So again, we look at case law, we look at the Highways Act, and we put that into the context of actually dealing with claims. And I think that's useful for highway authority employees. So they look at things from the lawyer's perspective rather than just purely and simply from the perspective of a potential defendant. Someone asked me on Thursday last week about occupiers' liability under the Occupiers' Liability Act 1957. So this was an accident that didn't occur on the public highway, but occurred on land that the highway authority owned. And the question that I was asked is, if children are playing on land that we own, do we owe those children a duty of care? And the answer is yes, you do. And if they sustain injury as a consequence of playing on land that you own that isn't public highway, you as a highway authority, just as any other occupant of the land, can be liable for loss. Interestingly, the duty that you owe is greater to children than adults, and theoretically you also owe a duty of care to trespassers. So if someone has climbed a fence to gain access to a bit of land that you own and sustain injury as a consequence of something on the land, then potentially you are liable to them for that loss, even though they're trespassers. What I do, Andrew, with cases is I give you the citation so you can actually find the case and read the entirety of the case. So yeah, I always do that, and I'm happy to do that. If again there was a case that I think was particularly significant, I will draw that to people's attention, as I'll do in a moment or two, as you'll see. So thanks for that, Andrew. What about mud on the road? And again, liability for road users that deposit mud on the road. So again, I'm sometimes asked about quarries or farmers or plant hire businesses that are spewing mud on the road when vehicles are going from their site onto the highway, etc. We'll look at that. And again, here we'll look at the Highways Act and what it does with regard to protecting you as a highway authority in connection with cleansing and recovery of expense. Car parking is something that I'm always asked about. What about Mr. Y, who's always repairing his car, his daughter's car, and his friend's cars on the highway? He's got a little sideline that he's operating as a highway authority. What can we do? What about the issue of obstruction? What about people charging their electric vehicles on the highway? What can we do about that? I'm often asked about car dealerships putting cars not on their forecourt but on the grass verge. Can they do it? How do we manage it, etc.? When I first started doing this work, Lyle, I was always asked about fast food vans and parking laybys or parking in the highway, and what do we do to get them off? These days, the question is, we don't want them off, we license them, so we're generating revenue. And in the good old days, again, there would often be questions about travellers. And these days, most highways authorities will be very wary about doing anything in connection with travellers on the basis that travellers will immediately start issuing arguments about human rights. And therefore, again, in the past, that was a hot topic, tends not to be as much as a hot topic as it used to be. Scaffolding and skips on the highways and licensing. Again, I'm often asked about those sorts of questions. And again, some interesting sections of the Highways Act that help us with regards to that. Trading on the highway, again, constituting a nuisance, so we can take action if necessary. We'd also talk about buskers and various things. Andrew was asking about case law. This case of Carpastis against Herts County Council was a case where the County Council was pursued by the parent of a child who sustained personal injury as a consequence of playing leapfrog on a bollard on a public footpath. And the bollard wobbled, and the child in leapfrogging over it sustained not really serious injuries, but some injuries, and brought a claim. Are you, as a highway authority, under an obligation to ensure that furniture on the highway or indeed on the pavement is safe? And the answer is you would be expected to consider that children walking along a pavement confronted by a bollard might jump over it, and therefore you're under an obligation to keep it secure. Quite bizarre, to be honest with you. But again, I go back to the point I made earlier. Your duties and obligations in connection with children are far higher than duties and obligations that are owed to adults. Special defence we've spoken about in the section 58. We have a look at that in a lot of detail. Trees in the highway. Again, who's responsible for cutting vegetation? If I'm an adjoining landowner and I have trees on my land, do I owe you as a highway authority or users of the highway a duty of care? The answer is yes. If trees are diseased or damaged, and the diseased or damaged tree were to fall on the highway, injuring a passerby, pedestrian or vehicle, then I, as the landowner, are liable to them for loss or injury. However, if the tree is healthy, and the storm is a sort of tempest that just blows up, as we've had in winter and summer months from time to time, and the tree is healthy, then I'm not liable. So that means I, as a landowner, am under an obligation to inspect the trees on my land and to ensure that if they are diseased or damaged and therefore likely to generate liability, then I undertake some form of management relating to them. You as a highway authority are empowered to go onto my land in the event of an emergency to attend to them and to transmit the cost associated with that attendance to the landowner. So interesting. We also talk about the right of a highway authority to plant trees and duties and obligations relating to the trees in that context. So again, just a snapshot of some of the things we'll talk about. Highways and development. We talk about creating highways. We talk about issues relating to town and country planning, relating to a highway authority being permitted to carry out works that are described as permitted development in connection with the creation of highways. And we talk about what a developer needs to look at, why you as a highway authority will be participating in planning decisions. And then we'll also have a look at 106 agreements, and we'll have a look at Section 38 agreements, contractual commercial agreements between you as a highway authority and me as a developer. So what sorts of things would a Section 38 agreement contain? What would a Section 38 agreement look like? What do we as a highway authority have to do with regard to negotiation? Again, a really interesting topic for me, because I looked at this always from the perspective of the developer. So again, we have a discussion about that, and we have a look at what makes a good Section 38 agreement, dealing with these sorts of issues, as I mentioned on the slide there. We then look at Section 104, the water industry, what happens with regard to drains and sewers beneath the highway, particularly with regard to development. Going back to what we said right at the beginning of the day, we once again revisit the extent of the highway and talk about limits of the highway, the hedge-to-hedge principle, the ditch-to-ditch, fence-to-fence principle, the assumptions that areas of land between the two are highway, and the fact that these presumptions are capable of rebuttal. So the general principle is that if there's a public highway running between two hedges, the extent of the highway is all the land between the hedges. But that presumption is rebuttable. So if I can show you that the highway was constructed in 1947, and that on construction there weren't any hedges, but there was in fact a series of fences, and if I can show that the hedges were in fact planted in 1963, then the hedge-to-hedge principle doesn't apply. We also talk about control of the subsoil and control of the airspace, which again is interesting. We look at fencing, we look at liability for embankments and retaining walls, etc. And again, look at it from a practical perspective. So hedge ownership, what happens if we've got hedges that are overhanging the highway? As a highway authority, what can I do? Can I compel the landowner to properly manage vegetation, or can I attend to it myself? We'll look at the law, and we'll look at the practicalities sitting behind the law. Vertical extent of the highway, what do you own? What can I do as a landowner if I want to undertake airspace development? Generally speaking, I'm going to need some form of license from you. Generally, you will own a reasonable height above the highway. What is a reasonable height? Well, depends on locality, but you're probably looking at sufficient a height to enable appropriate street lighting to be installed. And then diverting and extinguishing the highway, we talk a lot about that. Diverting the highway and extinguishing, the basic principle, once a highway, always a highway. So, a highway will only end if it is extinguished, or if it will only alter if it is properly diverted. So we'll talk about the law relating to it. Andrew, yeah, I produce over 140 pages of notes. So the notes are extensive. They're normally sent out electronically, Andrew. And what I do during the day is I will refer to snippets of the notes, but really rely on the slides, which again are available to you electronically, Andrew. So then we deal with the practicalities of highways issues. And this is another area that I didn't used to deal with to start with, but I found that I was asking lots of questions about it. So dealing with customers, negotiating with members of the public. So if we're having a meeting, what do we need to know? What are the facts? What is the law? Have I got a legal team that I can call on to have a sort of preparatory chat, or are there things that I can find out for myself? What are the aims and objectives of the meeting? What could possibly go wrong? Can the meeting be recorded? Should I make a contemporaneous note of our conversation? Should the meeting be subject to contract or without prejudice? If it's subject to contract, any agreement that is reached is of no consequence until it is, after the event, reduced to writing. If it's without prejudice, anything that is said cannot be utilised in connection with any proceedings thereafter. So am I going to have a without prejudice meeting with Lyle to discuss our boundary dispute? If we have such a meeting and then we reach an agreement, could we say the meeting is no longer without prejudice, but it is subject to contract, and agree of some terms, and then enable our respective lawyers to draft documentation that we're bound? Simon, it is, and that's something we talk about. I've had that in a Q&A session before. Use of the planning legislation, perhaps a better way than diverting or extinguishing. Yes. So again, going back to negotiation, if we reach an agreement, what do we do with it? Something that's really interesting at the moment is effective communication. And what I always say to anyone that will listen is, I've seen cases that have ended up in the Court of Appeal in the Supreme Court. And I've been fortunate enough to work with barristers that have dealt with cases of sort of national importance. And in the last year, I've had 3 different barristers involved in cases in the Court of Appeal in the Supreme Court. And on 3 occasions, they all said to me exactly the same thing. We were fortunate in that right from the start, our client, either the claimant or defendant, was reasonable. The other side were threatening to issue proceedings and being cynical with regard to agreements. Yes, Martin, there are issues on 278 agreements. There is case law on that and APC, which we can talk about. So going back to this point here about communication, if we're sending an email to a third party in connection with an issue, what does that email look like? Can we phrase it so that it doesn't appear to be quite as contentious? What I always say to practitioners, highway engineers, anyone working for a highway authority, anyone indeed, don't ever threaten court proceedings unless you are actually able to bring those proceedings and you have the wherewithal to do so. If you don't, then you're better to say, I'm going to reserve my position with regard to any legal steps or measures we as a highway authority may take against you, rather than saying, unless you do this within 7 days, I'm going to bring proceedings under the Highways Act to compel you to cleanse those ditches and to allow me to come onto your land to install another ditch to prevent flooding. It's that sort of thing that I think is important. Only when you've seen litigation and you've seen county court and high court trials, or indeed appeals, do you realise the seriousness of what communication can look like. And again, last week I was talking to a highway authority officer that had been involved in a court case in the Court of Appeal. And he said, I wish someone had told me what you've told my colleagues about the importance of making sure when we're having meetings, when we're sending letters or emails, that we're confident that they look as if we're behaving reasonably. Because he was saying in this particular highway authority that ended up in the Court of Appeal, some of the correspondence and some of the communication that had been passing between the parties right from the start painted the highway authority in a particularly bad light. And then the next thing we talk about, and this is really towards the end of the day, is giving evidence at court. And again, just recently, I was talking to a highway authority where some officers of the highway authority were described as experts in giving expert evidence. And I explained to them, if you're described as giving expert evidence at court, then you become an officer of the court. So if Lyle is an expert in connection with highway maintenance and is described as an expert in a witness statement, his duty when he's giving evidence is not to his employer, the highway authority, or not to his client, the claimant, but to the court. So Lyle is obliged to tell the court anything he knows, in his opinion or his view, relying on his expertise about the incident or accident, whether it helps his employer or not. The best example I can give you of that is, the Horizon inquiry. Did you see the guy, was he called David Jenkins, who was an employee of Fujitsu, who was giving evidence at court but described as an expert? The moment he's described as an expert, he has to be told by his lawyers, and potentially wasn't, looking at the Horizon inquiry, you've got to tell the court everything that you know. So if you know the Horizon system has its defects, even though you're working for Fujitsu, and even though that's bad news from a Fujitsu or post office perspective, you've got to tell the court about it. So giving expert evidence is important. If someone, your legal team, for example, is producing a witness statement for you, you need to know that when you're giving evidence at court, you will be asked to confirm whether that statement is true, and the solicitor or barrister for the other side will cross-examine you on that statement. So if there's language that you wouldn't use, or language that you wouldn't understand, or words are written in the statement that aren't your words, you can be tripped up. And I've seen that happen to someone. A statement in a written statement referring to something, and this barrister for the other side saying, "What do you mean by that?" And the witness honestly said, "Well, I didn't write those words. They were written by the legal department." Well, can you imagine how much of a significant statement that is? And you can imagine what the next question is. Well, what else in your statement wasn't written by you? Let's go through it from the start to the beginning and just agree exactly what are your words and what aren't. So giving evidence at court is disconcerting. It is stressful. And one of the things I do in this section of the presentation is try and arm you with as much information as I can to protect you as an individual and also to protect your organization. So I would say if my legal team has asked me to prepare a witness statement, then I would prepare it in draft. I would send it to my legal team so that they can look at it and consider it. Any amendments that they make, any additional sentences, phrases, paragraphs, I am going to look at long and hard, and I'm probably going to say, can I change it so they're in my words rather than your words? We look at magistrates' courts hearings, county court hearings, and we talk very briefly about the appeal routes that are available. So practical tips about how to answer questions. What happens in the court process, evidence in chief, cross-examination, etc., and the importance and significance of witness statements. And then the last thing we do before everyone goes, and I can have to say by the end of the day, they're fed up with me, to be fair, so they're dying to get away and catch the train. But before they leave, I go through resources and tell them about useful textbooks, useful resources that are available. Some of it involves spending money on books. I also refer to free resources. There are lots of barristers' chambers up and down the countryside that produce resources on their website that are free to access. So I talk about all these resources and indeed more. So that, ladies and gentlemen, is a scamper through how a day's face-to-face training would look like. Now, there's a number of things. First of all, if you book to go on the course, like Martin was suggesting and like Andrew was suggesting, if I am forewarned about a particular topic, then I'll happily incorporate that into my presentation. On the day itself, as I mentioned in my introduction, I allocate time for questions and I take time to answer questions. Where I can't provide a response, I will say, there's an email address, send me an email and I'll get back to you with regard to a response. And if the delegate wants me to share the response with others, I'm happy to do that. So the day is packed. There's lots and lots of things to talk about. I try and make the law as entertaining. So I think I'm muted. Strange, I don't know. I think someone's muting. Yeah, I try and make it as entertaining as possible. You're going to say, well, hang on, Ian, you bored us to death for the last 50 minutes. Perhaps you're over-egging it if you're going to say it's entertaining. Perhaps I'm better off saying it's not quite as boring as you'd imagine from a lawyer's perspective. And so we have a bit of fun. We talk about all manner of different things. I try and ensure that people get value. I'm conscious of the fact that you've taken a day out of your valuable work time to come and listen, and that their travel and expenses and everything else that goes with it. And I try and ensure that I give value for money. So what I'd like to do now is just sort of trawl through some of the questions that we've got. So, right, we've got Sean, yeah, drainage issues we can talk about. The idea of producing webinars, Lyle and Cheryl and I have spoken about. I'm sure, Lyle, that will explore that and provide details to attendees today. James, your question. In the event of a fatal or serious accident, to what extent, from your experiences, have traffic signs, including road markings, been challenged, both generally but specifically whether prescribed or not? And if prescribed, whether been specifically authorised? Yeah. What were the consequences of non-prescribed and non-authorised status of the signs in these situations? Yeah, James, each case turns on its own facts, okay? Signage or lack of signage can be an issue depending on the accident. Again, this is something that we would look at. And again, James, we would look at some case law to give you a flavour of what the courts are thinking and the sorts of steps that you can take to mitigate risk. But James, what you have to do really is say to yourself, this is a sort of an overview or a framework, but each case, as I mentioned, does turn on its own facts. So very difficult. But again, James, if you were to raise a particular incident with me at an event, I would go through it with you and look at the sorts of things the court would look at in deciding liability or not. So great question. Thank you for that. Andrew, we've covered that. And I've mentioned transcripts, etc. Normally, Andrew, during the day, what I'll do with a case is say, look, that's the legal principle that you take from that decision. To have a sort of deep dive into case law, depending on the case, can be really complex. That London Borough of Southwark case that I mentioned, identifying the extent of a highway, you could probably spend a day looking at that case if you wanted to. Okay, but certainly I would refer you to a citation that would enable you to access the decision, or alternatively, I could send you a copy of the judgment if I had it. Simon, we've talked about that. Yes, planning might be a better route than closure or diversion. Right, yes, we do cover gritting in winter, sort of ploughing, etc. Icing issues, Sarah. Maintenance issues with regard to gritting schedules, revision of gritting schedules, consideration of climate change, and resources available for gritting we talk about. Course on highway drainage flood control will be of interest to you, yeah. Legalities of income generation. Imran, that's something I normally don't look at, okay? But it is something, I'm going to take a photograph of that, actually, if I may, Lyle, and we'll have a look at that and see if that's something. And if it is of sort of general interest, then we can build into that. So just bear with me while I just take a photograph if I can. My phone isn't talking to me at the moment. Let's try again.
I can give you access to the chat anyway.
Oh, brilliant. Thank you, Lyle. That'd be fantastic, right? TTM, briefly. Barry, the law in Scotland is different. But Barry, I've been doing some work on that. I do lecture on Scottish land law, and therefore I haven't spoken to Lyle about it, but I could now provide an equivalent course for Scotland. So we could do that. Again, that's an issue for Lyle and budgets, etc., and feasibility. But certainly that is something that I could cover. It wouldn't be worth your while, Barry, attending the English and Wales events that we're currently offering, but it's perhaps something that Lyle, Cheryl and I can have a look at in connection with Scotland. Sean, if there are ditches along the side of the highway, also borders, who has responsibility for maintenance? Yeah, you can maintain them if you wish. The issue is if it borders the private land, if it's on private land, then it should be the responsibility of the adjoining landowner, Sean. But you can, as a highway authority under the Highways Act, access and cleanse yourself. Right, okay, Imran, I get that point. And Barry, yeah, got that point as well. I'm conscious of time, Lyle. Anything that you want to add what I've said? I've got 4 minutes or so. So again, keep firing the questions. But anything else that you can think of, Lyle?
Not really, really worthwhile doing, and thanks for the comments. We will take all of those on board when we're considering the sort of the one-off topics and sort of maybe 1 or 2 hour sessions in each of those, but we'll have a look at those definitely with Ian. One thing, and you mentioned snow and ice, and there's been a couple of questions there about winter maintenance. We also run a winter services decision-making course at IHE. It might be something we may need to look at. We may need to look at that. We're not saying anything contradictory within each of those courses. I'm sure we're not. I'm sure
I don't think we would be, but
they are all experts. But that's another course which is run on its own. So yeah, great run through of what we do there. Just quick selling point from IHE: it is cheaper to join all of these courses if you're a member than a non-member. So if you're not already a member, consider becoming a member. But I think we've got lots of food for thought there, certainly for future development of some of our training. And
yeah, got that, David. It's winter service.
Yeah, okay, David. Appreciate it.
Yeah. Thank you. Yeah. I think the other thing, Lyle, is as Lyle mentioned there, at the end of the day, if you're not members, I think great value to join. And as Lyle sort of touched on, and having this event, the organization is willing to listen. And that's certainly, Lyle and I and Cheryl and I are happy to create courses. If there's demand, happy to create it. And I think the other thing is that, I don't know whether you're aware of this, Lyle, but sometimes IHE will ask me to go into a highway authority and do bespoke training for that authority. So that can arise. So just recently I was at Plymouth City Council on behalf of the IHE doing a day's course for them as an in-house course. And before the course, the person at Plymouth who organised it, I said, look, send me a wish list of what you want me to cover so we can personalise events such as that. So you've got the face-to-face training, predominantly in Birmingham, isn't it, Lyle? The main
predominantly,
face-to-face training.
If there's demand for somewhere else, we can either have it in-house or take it to a different location depending on the demand.
Yeah, exactly. So, Lila, I've got nothing further to say. I don't think we've got any additional questions or comments. I've put my email address on there. Lyle, if I get any inquiries or any questions, if I may, I'll share them with you and Cheryl. But if you have any sort of burning questions, drop me a note. As long as you don't, I always say to people, Lyle, as long as you don't abuse me and send me 10 questions a day, if you send me a question every now and again, I've got the time, hey, happy to help on a one-off basis. Great.